welcome to the Michigan Court of Appeals. We are the panel, the Grand Rapids panel for the September 2023 case call. My name is Brock Swartzel. Joining me today are Judges O'Brien and Feeney. We will be taking up the first case on today's docket, People v. Schurr. Given the public attention this case has garnered, at the completion of this oral argument, the court will take a 15-minute recess so that those here for only the first case can exit the courtroom without causing disruption to the lawyers and parties in today's other cases. With that, I will call the first case, People v. Schurr, docket number 365104. And before the lawyers begin, I do want to thank them on behalf of the panel for submitting excellent briefs. It's been very helpful for us in preparing for today's oral argument. Mr. Borgula, as the appellant, you may proceed.
May it please the court, Matt Borgula on behalf of defendant appellant Christopher Schurr. I'd like to reserve 10 minutes for rebuttal. Your Honors, we are here today on interlocutory appeal, asking this court to affirm what the law is and not what the lower court thinks it should be, and correct the error of law made by the lower court when it denied the defendant's motion to dismiss and the motion to quash. On the morning of April 4th, 2022, Grand Rapids Police Department Officer Christopher Schurr was on patrol alone on the southeast side of Grand Rapids. He executed a lawful traffic stop on a car driven by Patrick Leoya. An altercation ensued that resulted in the tragic death of Mr. Leoya. As a result of that incident, Officer Schurr was charged with murder in the second degree, and after a preliminary examination, the case was bound over, and the defendant moved to quash that bind over order and also moved to dismiss the charge, which the circuit court denied. We're here today as the appellant has raised 4 grounds on appeal, the first of which is that the circuit court erred as a matter of law in its application of the fleeing felon rule in common law, and thus abused its discretion in denying the appellant's motion to quash and motion to dismiss. As this court is aware, the law allows police officers to use force to make an arrest, and the common law allows police officers to use deadly force to stop a felon from fleeing when the officer reasonably believed a felony had occurred and that the fleeing suspect was the one who had committed it. And here the undisputed facts showed that Mr. Leoya committed several felonies and also that he was fleeing or using force to prevent the arrest. The record below, I think, is undisputed that Mr. Leoya had resisted in obstructing an officer, which is a felony, had disarmed a police officer, he had possessed a taser, and he committed larceny. There were also other felonies of which Officer Schurr could not have been aware of at the time because Mr. Leoya had refused to provide him his identification or allow him any access to his car. There's no question here that Mr. Leoya is the one that committed these felonies because he is the one that committed them against the officer. So this is not a case where the court, as in Fiedler, would have to consider whether or not the officer had been using deadly force against the right individual. And under the common law in the state of Michigan, that should have been the end of the inquiry. But here the district court added a third element and indicated that there was a question of fact for a jury to determine whether, at the instant the shot was fired, the location of the shot was reasonably necessary to prevent his escape.
Now, the case law, I think, makes pretty clear that there is a necessary component to the
engage crime to make arrests. And that is the reason why the law has diverged. You don't want private citizens doing vigilante justice. And in some of the cases you've seen that created this split in the law, you had private citizens who made arrests or tried to make an arrest, and as someone was running away, they would use deadly force. Police officers, unlike private citizens today, do not have a duty to retreat. In fact, they have a duty to advance. That is why there is a different standard of what an objectively reasonable officer would do, at least in civil cases.
Why is a necessary element incompatible with a police officer's duty?
I think it is necessary because he's fleeing. And under the common law, that was inherently dangerous. And so the error occurred when the district court and the circuit court placed additional sort of considerations when determining what is necessary. They talked about the amount of force used. Is it necessary to use this much amount of force? Is it necessary to shoot them in a particular location? Was it necessary to chase? The common law does not consider that. It was a simple rule, and for good reason. If the legislature, as the people in People v. Couch, the Supreme Court said, wants to set rules for officers on when they should chase, under what circumstances they can do that. But the Supreme Court in Couch considered the issue and decided we're going to keep the rules simple until the legislature speaks, because these are important policy considerations. I agree with the court, and I agree with the lower court, that perhaps this is something that a legislature should take up. And the Supreme Court urged them to do just that, but they did not. And as times change, laws get passed to reflect societal norms, and here there is no law that's been passed. Even the requirement that it be necessary, reasonably necessary, there's no support for that under the law. And when you add reasonably necessary, I think the court went to another level. I think the court was trying to place additional burdens on the police officer in this case to show that he could have had other options, or he could have done something different, and that is not the law. In the civil context, which a lot of our law is taken from because there's been more litigation, it's an objectively reasonable officer standard. And here, the court, when talking about self-defense or talking about common law use in response to force, would not even consider whether or not an objectively reasonable officer in that circumstance would have used deadly force. And that circumstance was very dangerous. And the facts below supported it. And the district court opinion supported it. That under any standard, this situation would have put any officer in fear of himself and of others. It was a suspected felony stop for a stolen vehicle. It was a highly populated area. This is not a deserted road where someone is driving away and there's less chance they're going to run into somebody. It's a busy street. It's 8 a.m. on Monday morning. What do people do at 8 a.m. on Monday? They go to work, they go to school, they're outside of their house. Mr. Little refused to identify himself. He came out of the car. These are all things that would make an officer suspicious of what's going on. He refused to give identification after the officer asked in a quiet tone, non-threatening manner, "Please go get your driver's license." Mr. Leola instead fled, and in the process, he struck the officer.
Can I ask, we have populations, portions of our population who, when an officer approaches them, might be under the influence, alcohol or drugs, might have significant mental health issues. Is it any time that an officer asks, and this person who's either incompetent or under the influence or has now climbed into their amygdala, that they don't respond appropriately by stopping or answering or staying in the car, that we're going to be facing these sorts of situations?
I think the facts of this case show that Mr. Leolia appeared confused. You can see on the police officer's dash cam that he asked, "What did I do?" And that followed after the officer asked, "Do you speak English?" Because he was wanting to make sure that he understood the commands he was giving him and the questions he was asking. So could there be circumstances like this where officers are faced with that situation, but they're trained to handle the situation? And here, Officer Schurr took the necessary steps to make sure that the suspect in this case understood what he was saying. He asked him, "Do you speak English?" Answer, yes. It wasn't until after the flight and during the struggle that I think Officer Schurr realized that this person could be under the influence of something else. So he didn't have the opportunity to ask. Again, it's 8 a.m. on Monday. The likelihood that someone's going to be driving with a .33 blood alcohol level, I think in Officer Schurr's experience, is pretty low. So the fact that he was running, and this is not in the record what he was thinking, but it's suspicious of the fact for the felony stop, not that he was drinking and driving. I don't know if that answers the court's question.
I guess not really. I'm just trying to focus on the fact that not everyone is going to be providing the same response that you would anticipate: stop and stay in your car, those sorts of things. But we have people out there in the world who have significant PTSD. They have significant mental health issues, are under the influence of some kind of substance. And any time that somebody doesn't stop, stay in the car, I'm just trying to figure out, are they fleeing felons merely because they are not responding to the things that, there's just going to be this population of people who might not. And I'm just trying to figure out how that fits into everything.
Well, they might be fleeing, but I don't know if they'd be a felon. And so the rule anticipates that someone had committed a felony offense before you can use deadly force. So you have to be fleeing. In other words, you have to be trying to get away, and that can include resisting and obstructing. That can include fighting with the officer. It doesn't have to be a race down the street. But yes, I don't think that that's a situation where if someone's just confused and takes off, that you can use deadly force, because until Mr. Leola rammed into and struck the officer, there's no felony that he's aware of that would raise the suspicion that a reasonable officer would think a felony had been committed. And once he interacts with them, the felonies increase in severity and in number to the point where he ultimately disarms the officer of his taser. And there was a lot of factual development below about whether or not it's a dangerous weapon. And even the government's expert, I think in this case, would acknowledge that while it doesn't have the same effect if it's a cartridge versus a drive stun, it causes incapacitating pain. And so what you had was Mr. Leolia, after fighting with the officer for over a minute and a half, where the officer tried everything that he could in his training and experience to arrest Mr. Leolia without using deadly force. And according to the district court, those efforts were to no avail. The district court said that Mr. Leolia was impervious to attempts to arrest Mr. Leolia prior to the time he brought out his taser. And so that's the situation we're dealing with. It's not a situation where somebody just jumped out of the car and ran, and the officer decided I can go ahead and shoot him because I have a reasonable belief he committed a felony. The officer showed incredible restraint. A minute and a half fighting with another person is an incredibly long time, incredibly exhausting. It was only after a minute and a half that he decided to take out his taser. And then the following minute, Mr. Leolia had grabbed his taser. And at some point, the officer lost control of that weapon. It was only then, after 2.5 minutes of hand-to-hand combat with Mr. Leolia, did he decide that he was going to use deadly force and take out his weapon. He hadn't even taken it out. And even then, when he took it out, he warned him again, drop the taser. Those are all the things that he was trained to do. And that is why the captain in this case, who's an expert on GRPD policy and training and tasers, testified, and it was unrebutted, that Officer Schurr followed his training and he acted as a reasonable officer would have acted in that situation.
Mr. Regula, this kind of leads into a question I had in terms of, you have two other justifications. You have the Self-Defense Act, and then you have the use of force when met with force. I believe the lower courts collapsed those two justifications into one. And I'm wondering what your views are on whether they are distinct and should be handled distinctly, or whether they should be collapsed into one and handled as a single unit.
I think the court erred on both those grounds. I don't think they should be collapsed, primarily because the use of force in response to force has not really been developed in the law. There just haven't been many cases where someone has been fighting with a suspect, been disarmed and charged with a crime as a result. And so the language we see in the courts relating use to force in response to force is usually in relation to private citizens making a citizen's arrest. And so what the court did is they said, well, I'm just going to call this self-defense. And the officer always has a right to self-defense, just as a private citizen would. But we have to have some level to recognize the fact that we are telling officers to go out there and protect the public, to make arrests, and not to retreat. Their job is not to retreat. A private citizen's job is to retreat. And if a private citizen doesn't retreat, they may lose that right to self-defense. If a private citizen is the aggressor, they may lose that right to raise self-defense. We're telling police officers, go investigate, go into the neighborhoods, look for criminal conduct, protect the public. That is different than what we're telling private citizens. So to say that the only defense available to police officers is that of a private citizen doesn't give any account for the fact that we've tasked police officers with doing the job. And here he did the job.
People versus DAS, aren't we bound by that? And that sets the standard for a police officer in these situations?
I think in DAS, the issue wasn't actually raised. So I don't think that the court, the use of force and response to force wasn't raised. I don't think you're bound by DOS in the sense that if you're going to set a standard for what a reasonable officer would do in a situation, I think there are certain rights that a police officer should be able to raise so that it can address the fact that in Couch and Tennessee v. Garner and Graham v. Connor, all cases that came after DOS, that the officers have some defenses that a vigilante, a private citizen making a citizen's arrest doesn't have. So I understand the language in DOS, but I don't think you're bound by that, given all the cases that have come after that.
Mr. Regula, if you want to reserve 10 minutes, you have about 2 minutes left.
With regard, and I'll make the quick point, Your Honor, I believe you asked, did the court err when it set the self-defense standard? I think the error came when the court stated that the officer, his only defense is if he honestly and reasonably believes that he or she is in fear of great bodily harm. And here I don't think that any courts in this situation would disregard the fact that the officer is in a different situation.
Than a private citizen.
Than a private citizen.
Because the officer is trying to make an arrest.
Yes, a lawful arrest. And here, that's an important distinction here. Everything he was doing was within the bounds of the law. The stop was lawful, the arrest was lawful. There was no allegation that, even by the people, that he had violated the law or the constitutional rights of Mr. Leoya, except for the very end. And I think the court has took only one instant in time when viewing whether or not he was acting in self-defense. And I think that's error as well. The district court, and this was affirmed by the circuit court, only looked at the instant the shot was fired. And there is absolutely no case law, even in Doss, that doesn't consider the totality of the circumstances. At some point, the officer has some constitutional rights too, and has a right to due process, and that includes looking at everything that occurred leading up to his decision to use deadly force. You don't just look at the instant anything happened under the law. And the officer's actions are always viewed under the lens of the totality of circumstances. And that includes when a defendant's constitutional rights might be violated in a search. My time is up, Your Honor, so I'll reserve 10 minutes.
All right, thank you.
Good morning, Your Honors. Katie Went with the Kent County Prosecutor's Office on behalf of the people. Also, Mr. Becker is here on behalf of the people, and I would like to make the court aware that the victim's family is in the courtroom today. I know the court is well-versed in the facts, the arguments, and the law of this case, so I don't want to belabor my first point, but as I've been preparing, as I've been drafting my brief and preparing for this argument, I think it's very easy to get lost in the weeds of where we are in this case. And remember to forget the current posture of this case. We're here after a district court's decision to bind over a defendant following a probable cause determination. The job of this court is not to assess whether or not the defendant is guilty beyond a reasonable doubt, but whether or not there's questions of fact that must be submitted to a jury. Time and again, the defense has said we didn't refute evidence that this was reasonable because they put someone on the stand to opine that the defendant's conduct was reasonable under the circumstances. We ask juries and fact finders all the time in self-defense cases to make these assessments without putting on a witness to say this was reasonable or not reasonable. We ask them to look at the totality of the circumstances. We ask them to look at all of the evidence and make that factual determination as the jury whether or not the defendant's conduct was reasonable based on the perceptions of the actor at that time. Now, we put on plenty of evidence at the preliminary examination. There was video, dash cam, body cam, and cell phone video showing the incident and the fatal moment, showing the struggle leading up to that. We have an eyewitness who said that Officer Schurr was in charge or in control of the fight the entire time that he was watching, that Mr. Lioya was never on the offensive. We have evidence about the taser's capabilities at the time that the fatal shot was fired.
It's an interesting point you raise. I'd like to talk about the taser for a moment.
Sure.
I believe below, whether it was the district court or the prosecutor, words like benign, merely pain, and such were used. Do you consider a taser in drive-stun mode as a dangerous weapon?
I think under the law, it could be considered a dangerous weapon at the time. But when we're looking at the factual situation here and whether or not deadly force was reasonably necessary, it's a proper consideration for the trier of fact whether or not this taser was capable of NMI at the time or a drive stun, especially
Correct.
from the perceptions of an officer.
I don't disagree with you, but even in drive-stun mode, there's federal case law that clearly finds that a taser in drive-stun mode is a dangerous weapon. There's people, or United States v. Brown from the 11th Circuit, Quiver from the 10th Circuit, and Wallace from the 9th Circuit. In Quiver, I'm quoting, "In either drive-stun or probe mode, a taser is capable of inflicting serious bodily injury, which is defined as injury involving extreme physical pain or the protracted impairment of a function of a bodily member, organ, or mental faculty." So it does seem that there's case law out there that a drive-stun weapon is a dangerous weapon. Fair?
Fair. And I wouldn't disagree with that point, by Your Honor, but I think it raises another factual question that we have for the jury that Captain McCursey actually highlighted in his testimony. And that's where we can't tell whether or not Mr. Lioya was just simply trying to break free of the officer.
And I get that point. I'm going to let you make that point, but I do want to just, before we get off kind of the characterizing what a drive-stun weapon is, it did not seem to me, but I'll go back and read the record, but it did not seem to me that the district court or the circuit court treated the drive-stun weapon as a dangerous weapon. Again, words like merely or benign or merely pain were used. Is that a problem for the prosecution?
believe it's a problem. I can't recall those exact words being used, but I do think it's a fair consideration for the district court and for ultimately a fact finder at a trial to determine what the taser's capabilities were at the time. Certainly, a jury could agree with the defense that he was in immediate danger of harm from the taser, but that's a question that must be submitted to the jury after they consider the conflicting evidence that he was just simply trying to get away. That there was no evidence during that struggle that Mr. Loyola intended to use that taser to hurt Officer Schurr, and whether or not how that plays into his honest and reasonable belief. All questions that must be submitted to a jury under this reasonableness analysis.
Let's look at a hypothetical. Let's say that there was a similar instance, and instead of struggling over a taser, they were struggling over a firearm. Would that be a categorically different situation in your opinion?
Again, Your Honor, I think it depends. These are such fact-intensive inquiries. So, what was the struggle leading up to that point? Was it just similar to this, where the victim
I would say
push away the firearm?
the exact same scenario, except it was a firearm rather than the taser and drive-stun mode.
I would say, to Your Honor, that is still a question that would need to be submitted to the jury. If every fact was the same and it was simply a firearm rather than a taser, there would still be a question of whether or not that person intended to use that taser and whether or not it was honest and reasonable belief for the defendant to believe that the person was going to use the taser or the weapon, firearm against them.
Okay, thank you.
Just one more piece of evidence with respect to the reasonableness of this conduct would be the path of the bullet from back to front. And I know that, I've pointed out several facts that would show that we can argue this was unreasonable. And Mr. Borgula stepped up here and he argued many facts that would show this is reasonable. And that's exactly what Doss says, that we have to submit this to a jury when there's conflicting evidence about the reasonableness of someone's actions with respect to self-defense. And I would disagree with Mr. Borgula's answer to your question, Judge O'Brien. I do believe this court is bound by Doss with respect to the self-defense standard for police officers with private citizens. The court very clearly says that, like the private citizen, a police officer must have an honest and reasonable belief of an immediate danger of serious bodily harm or death.
Does Doss bind us to apply that same standard to the force meeting force justification?
So I disagree with the defense that these are distinct. If you look at Whitty, the piece of law where it talks about use of force met with force, the very next sentence is that the former is usually analyzed under principles of self-defense.
And I think you're right in that Whitty says usually, and it does seem odd that we have these two justifications out there, and courts over and over have simply said, well, they're the same. There's no conceptual difference between the two justifications?
I would say there's not. If we're looking at force met with force in the course of an arrest, I think you have two defenses here. You have your fleeing felon defense and you have your self-defense. When we're looking at the use of force, any justification in the law, the force used against force must be proportional. It must be reasonable with respect to the harm. So there has not been any case law actually analyzing this use of force when met with force defense. And one thing that I think is interesting is the defense has never logically rebutted the logical inference of the standard that they're advocating for with this court. If they're saying I can use deadly force when met with force and that's it, there's no parameters, there's no safeguards on there. So force could be as simple as a push. Force could be as simple as throwing my keys at you. And to say that an officer can lawfully use deadly force against someone who merely shoves them, what that means in the course of this case is that Officer Schurr could have shot and killed Mr. Loyola almost at the instant he started running away. And that's not the law, and that's never been the law. And I know that they say in their brief that this is an oversimplification, that these are extreme examples, but I believe that it's necessary to go to these extremes because if this court is going to set a precedent that officers can use force when met with any force during the course of the arrest, I agree with Judge Feeney that we're going to have some results where there's people who are incompetent, there's people who have mental disabilities that don't know what's going on, they might be drunk, and all of a sudden they're at risk of being shot just in a mere traffic stop.
I think you make the argument in your brief that the necessity requirement of whatever test we're looking at is always a factual question.
I would say it's generally a factual question.
Generally a factual question.
Correct.
Does that mean that whenever a police officer is involved in a deadly shooting, that police officers can be subject to a trial for second-degree murder since the first three elements will be met every time?
I would not say so. I think there's several safeguards in our system that lead up to this.
So where do we draw the line on the necessity component, given that it is a factual question generally? Where do we draw the line and say, well, in the mine run of cases, it would not pass a prelim, but in certain circumstances it would? Where is that line?
I think it's an incredibly fact-intensive inquiry, and I've wrestled with this
Then
question.
doesn't that get us to trial?
Well, I've wrestled with this question this past week, and I think this court's decision on People v. Diaz provides a good example of when necessity wasn't really a question for the court. Granted, I don't believe it was raised in that issue, or in that case, but in that case, what we have is we have someone who was engaging in a high-speed chase with an officer, going up to 106 miles per hour, then showed that they had a wanton disregard for human life when they backed their car up into the cruiser when they could have backed it up into the road and continued to drive off. In that case, there's only one way to apprehend that person without causing danger to anyone else on the roads, and that would be to use force in that situation. Now, my reading of Diaz and going back to looking at the arguments from Diaz, I don't think that the prosecutor ever raised an issue of factual dispute and never put conflicting evidence about necessity before the court.
But that would be a case that you would say necessity had not been shown at a preliminary exam stage.
I think in that case, I don't have the preliminary examination transcript. I only have the court's opinion and the arguments that I was able to watch. But I think that is a much more attenuated of an argument for the prosecutor to make. And this, I don't even think this is a close call with respect to necessity. I think both sides have put forth arguments that this conduct, they've said, it was necessary for this reason and this reason. But I will say that I do believe that argument has been abandoned with this court because they don't argue the facts of necessity. They just argue it's not an element. It's a very limited issue presented to the court. But we've set forth facts that it absolutely was not necessary at the time. There's testimony that the officer had alternative techniques available to him. When the shot was fired, Mr. Loyola was on the ground. He wasn't running away. This wasn't a high-speed chase situation. He was on the ground, and Officer Schurr could have grabbed any of those alternative techniques. He had radioed for help. Presumably, help is on the way. We also have an eyewitness that I mentioned earlier that said he was in control of the struggle. Taking all of those facts, that presents a factual question to a jury whether or not the necessity was met here with respect to fleeing felon. I would argue the same thing I did earlier, that they haven't rebutted the logical inference of what they're asking this court to do. We talked about R&Os earlier, and the second that someone says, no, officer, I won't do that, I won't step out of my car, they disobey a lawful command, that's an R&O under Michigan law. That is a felony. So the second someone says that, an officer can't use deadly force against that individual. That's never been the law. And I can't imagine any court in the state, let alone this country, saying that an officer can shoot someone just for disobeying a lawful command. There has to be an element of necessity. There has to be a question of, was it necessary to take a human life at this point rather than let this person go, or continue the fight to try to apprehend them? There has to be parameters to safeguard human life here. And with respect to the element of necessity, I know it's the defense's position that does not exist for police officers, and Judge Swartzel, you engaged in some dialogue with Mr. Borgula about that. I would point this court back all the way to Blackstone, where Blackstone sets forth the fleeing felon defense. And Blackstone says, provided that he cannot otherwise be taken. Now, Blackstone doesn't say necessity, but that's what that means.
Well, and that was back in an age when the felony crimes were all violent, and that is no longer the case in our society today.
Correct. I don't believe any of the justifications personally exist for the fleeing felon defense that used to back in the common law. But taking the defense's argument that we have to look at the law at that time and not look at the utility of this law today, Blackstone even provided this necessity element. And then we get to Whitty, which is the case that they rely on to show this distinction in what I call the knowledge component of the fleeing felon defense, where an officer can have a reasonable belief, but a citizen using deadly force has to have actual knowledge of the felony. If you look, I didn't include it in my brief, but I found it in prepping today. If you look, there's a footnote right there that the court adds, and they say there's no further distinction between police officers and private citizens with respect to the use of deadly force during an arrest.
You make an interesting point, because I believe in your brief you raise concerns about creating a two-tiered system of second-degree murder for private citizens versus officers. We already have that. We already have a two-tiered system when it comes to justification. And you just mentioned it yourself, that police officers only have to have a reasonable belief that a felon occurred and that this person was the actual person who committed the felony, where a private citizen has to know with certainty to get the justification. So isn't this concern about a two-tiered system of second-degree murder? Our courts have already stamped approval on that.
I raise that concern because the Supreme Court in Couch, the plurality in Couch, actually raised that concern
Sure.
themselves in their footnote 1. They said this could potentially raise equal protection concerns. I do think there are reasons that our courts and our legislature can find for treating police officers and private citizens differently under some situations, such as the duty to retreat or this knowledge component.
And it may be that a private citizen would be the one to make that complaint because the private citizen is being held to the higher standard. If there's an equal protection issue, it's the private citizen who would have the equal protection claim, not the police officer.
If we're looking at a civil suit with respect to equal protection. But with respect to my point about Whitty and the court saying there's no further distinction between these courts, I mean, this court is bound by Whitty. This court is bound by that case law. And Whitty goes on to cite with approval the Gonsler instruction in that case that says both officers and private citizens must exercise reasonable care in effecting an arrest without doing personal violence. And only where it's necessary can you resort to the use of deadly force. So if we have the Whitty court recognizing this necessity component, recognizing this knowledge component, and then saying the only distinction is this knowledge component, I would submit to this court that there's no question the necessity component exists for police officers as well.
Why didn't Fiedler include that in its standard of analysis then?
Fiedler didn't have to get to that point, Your Honor. That's my reading of it, because there was a question of fact regarding the officer's reasonable belief that the person against whom force was used was in fact the person who committed the felony. They didn't have to reach the question of necessity. Maybe it came up later, we don't know. But with respect to that decision, it was so limited with respect to that reasonable belief and the knowledge component. I wasn't there, I'm not on the panel, I don't know why they didn't put when necessary in there, but I believe that when they at least cite the law of fleeing felon offense, they say you can use deadly force when necessary. That is repeated throughout our decisions through this court and through the Michigan Supreme Court. Let me glance really quickly. I will rest on my brief for issues 2 and 4 otherwise, unless this court has any further questions.
I had a question with respect to the Self-Defense Act. There really are no cases saying how the prosecutor has to establish the absence of self-defense. Do you have anything with respect to that?
With respect to disproving self-defense beyond
Yes,
reasonable
because
doubt?
it's establishing at the prelim, when the warrant is executed, at a trial, you have to establish. And at the prelim, how do you do that? Have you done that?
I believe we have done so here, and I believe the way that you establish or disprove self-defense is by setting forth facts from which a rational jury could find that the conduct of the defendant was unreasonable given the circumstances, that they did not have an honest and reasonable belief. So we've done that by setting forth evidence, the video evidence, the eyewitness testimony, Taser's capabilities, the medical examiner of the bullet going back to front. We've established that through all of the evidence that we've presented. And we do this, we do this day in and day out with respect to other murder cases that we have or other force cases that we have where the defense is raising self-defense. It's not a new concept for the law. I think this is just a unique situation because we're looking at it from the lens of a police officer.
We were just talking about proving or disproving, or at least raising questions about justification at the prelim stage. There is recent case law that suggests that we shouldn't even be doing that. We shouldn't even be reaching justification because justification is a defense, not an element. There is a lot of case law going the other way, that you do look at justification at the prelim stage, and you don't challenge that on appeal, or at least you didn't in your brief. Is the prosecutor's position that it was perfectly appropriate to look at justification, all 3 justifications, even if we consider 2 that might collapse into each other at the prelim stage?
My understanding of case law, Your Honor, and I'm not sure of the exact case you're referencing, but my understanding
I think it's People v. Spears.
which I believe is an unpublished case, if I'm not incorrect. I could be mistaken on that. But my understanding of the law, to answer your question, is that the defense certainly can put on evidence of justifications at the preliminary examination stage. But it's been well established in Michigan law that affirmative defenses are generally reserved for a trial. If they put on evidence of a justification, that doesn't necessarily negate the elements that the prosecutor has been trying to prove. And with respect to a district court's decision, the case law says if there's conflicting evidence, and even if the evidence raises a reasonable doubt, then the district court still has to submit that question to a jury because that is a question of fact.
It's People v. Spears, docket number 357848. It is published, but I think it's published relatively recently, so.
I appreciate that. Your Honor.
And the only reason I bring it up is the circuit court judge, in reviewing the motion to quash, seemed to question whether at least some of what the district court judge took up was even appropriately brought up at the prelim stage. And I note that People v. Spears is a private citizen case. It seems that justification would almost have to be involved when you have a police officer shooting at the prelim stage. Do you agree with that?
I think it's completely appropriate. You know, I may disagree after I read through Spears again, but my understanding
You reserve the right to disagree with me.
Yes. I think it's completely appropriate for a defendant in any case to raise a justification at that stage. Now, whether or not that justification, the law says if the defense is complete at that stage, then a district court can dismiss the charges. So presumably, some defendants may want to raise a defense at the preliminary examination stage because they believe the defense is complete at that time. It's a risk that they take to bring forth that evidence. Many defendants don't. They wait until trial to raise that self-defense. I believe, you know, if we had further cases like this, and thankfully we don't have many cases like this in our community, but if we had further cases like this, I wouldn't be surprised if further justification evidence was raised at the preliminary examination stage, just given the nature, given the emotions in the case. However, I don't think that what the district court did here, how the district court weighed the evidence, looked at the conflicting evidence, and found that it was question of fact for the jury, I don't think that was inappropriate.
Thank you, I appreciate that.
Any further questions? Then I just ask this court to affirm the decision of the circuit court.
Thank you.
Thank you.
With regard to the justification at the preliminary examination stage, Your Honor, I think that in cases involving a police officer, which I don't think the Spears case was, there's going to be no point of a preliminary examination because, as the court has already pointed out, the elements of most crimes will have been met merely by the fact that the police officer is doing his job, and the only real issue is whether or not he was justified in doing so. And the concern here is if you don't permit the officer to raise facts that shows he was justified at the preliminary examination stage, then every case will be brought over for a jury to decide whether or not the officer acted reasonable. And I agree with the court, or at least the court's question, which is we already have a bifurcated system, and there's a reason for that. We have one in the civil context as well. And first of all, there's already a remedy outside of a criminal case that's pending as a result of this incident. There are administrative remedies.
Are you speaking of the case in front of Judge Maloney down in Kalamazoo?
I am.
Okay.
I am. And so there have historically the situations where, in some of the extreme examples, where someone is mentally ill or drunk or out of their mind, if the officer doesn't follow his training and uses force, excessive force, then the remedy is a civil lawsuit. And
I had asked a couple of questions about the taser being a dangerous weapon, even in drive-stun mode. The prosecutor, I think, indicated that sometimes it could be a dangerous weapon, but it's fact-intensive. How do you address her answer to my questions?
That the facts at the preliminary examination stage show that it's a deadly weapon. The law, with regard to possession of a taser, for example, indicates that a taser is designed to incapacitate temporarily or injure or cause death. So that's a statute. And so there really is no debate on whether or not a taser is a dangerous weapon.
Well, I want you to specifically focus on a taser and drive-stun mode, because there are the two modes. There is the mode that you can be incapacitated with the cartridges. And then you also have just the drive stun mode. And I just want you to address whether this weapon solely in drive stun mode was a dangerous weapon under the totality of the circumstances here.
It is, Your Honor. And the testimony at the preliminary exam by the expert from Axon indicated that while it doesn't have the incapacitating effect as the electrodes would have, in other words, it essentially puts you on the ground, the drive stun is designed to inflict pain. And if you use the drive stun in certain parts of the body, the face, the jugular, you can kill somebody. And that is the testimony of the expert at the preliminary exam. And if you look at the situation, Mr. Leoya had exclusive control of the taser, according to the district court and according to the video. He had transferred it from his left to his right hand, and he was in close proximity to the officer. The officer is yelling at him to drop the taser. And the reason he's yelling at him to drop the taser is because he knows how debilitating the taser can be, as he has gone through training and received a drive stun. Not only can it incapacitate, you can kill someone with a taser if you hit them in the neck. That was the testimony. You can crush their jugular. It's definitely a deadly weapon. And there's a reason that both of the individuals involved in the incident are fighting so hard over this taser. They both believe that it is a dangerous weapon. There's no reason why Officer Schurr would be grappling as hard as he would if he thought that this didn't pose a threat to him. Why would he possibly do all this without using his firearm first if he didn't think it was dangerous? Not only to him, but to everybody else around. And the testimony in the video shows that the second cartridge actually was shot into the ground. So there's no evidence that either Mr. Leoya or the officer knew that there wasn't a second cartridge. So it doesn't matter though, Your Honor. To your point, once it's in drive stun or whether or not it's the cartridge, it's designed to inflict incredible pain. And it does its job pretty well, which Officer Schurr knew. And again, with regard to the dual system, I believe that the circuit court and the people's position is that we don't want to have a separate system for police officers as private citizens. To my point, Your Honor, I believe that we already do. In the civil context, when you sue someone for assault versus when you sue a police officer for excessive force, totally different standard. And the law has recognized that for many years, and there's good reason for that, as I said before. Even in this particular example, if you look at whether or not, as the people have suggested, there were other means to arrest Mr. Leoya. Oh, he could have used his mace at that point, or maybe a nightstick. There's no evidence that he had any of those items, by the way, just that Captain McCursey said there are other things possibly available. But the district court found that Mr. Leoya was impervious. Impervious, that is the word the court used when viewing the videotape and listening to the testimony.
You're getting into at least around the issue of necessity, and the prosecutor made the point that if necessity is not a requirement of a police officer with regard to a fleeing felon, that would give license to police officers to use any amount of force at the slightest instance of seeing a felony and then the felon taking off. Doesn't there have to be some level of necessity or some guard against the use of force in any way, shape, or form in this context? Police officers can't use any amount of force at the slightest level. And I know in your brief you said that this was somewhat disparaging to the police officer community, but that doesn't really answer the question of, doesn't there have to be some necessity requirement placed?
Yes, Your Honor. And in common law, I think the necessity requirement, because the word is in the common law cases, that relates to it was necessary because he was fleeing, and that In those cases, they viewed the flight as inherently dangerous because the person had committed a felony.
That was also developed when
Right.
felonies were very violent. That's not today's world.
No, and that's why, in this case, Officer Schurr did not use deadly force until Patrick Loyola had committed several violent felonies. And that's why he followed his training. And so if the court's going to ask whether he acted reasonably, the district court already found that he did. He acted completely reasonably, and he spliced out one moment in time and said, we're only going to look at the moment the shot was fired. And that is not the law. If there's going to be a necessity component that involves reasonableness, this is a case where the officer acted reasonably. I respectfully disagree that this is going to turn into a situation where officers are going to just use deadly force when somebody walks away for no good reason. If only because the officers are not trained that way. And there are remedies when they do that. They will lose their job. Most officers love what they do and do it for a reason, because they believe that they're doing good for the community. They will also get sued individually and on behalf of the department. And so there are rules and laws against when an officer can do certain things. So to suggest this is going to be a slippery slope in the officers, it's going to be free rein for them to use deadly force in any circumstance without any possible consideration, I don't think is in touch with the realities of the situation. So while we recognize back in 1839, the law was different and the 9 felonies were inherently dangerous, here is a case where the officer followed his training. He did not use deadly force when he ran. He chased him, which he's required to do, according to Captain McCursey. He can't just let him go, as the people have suggested.
Was there anything in the training that said to pull a taser when you're in physical contact with someone? I didn't see anything about that in the transcript of the prelim.
The continuum of force allows him to use greater force than is being applied to him. And so if the knee strikes aren't working, if the open hand strikes aren't working, the verbal commands aren't working, he can use his taser. And now, could he have shoved the suspect and so he had a better shot at him? Perhaps that would have been ideal, but given the circumstances, the suspect went at him and grabbed the taser as he pulled it out. So he didn't have that opportunity to get a clean shot off, and that's why it didn't strike Mr. Loyola. So he's allowed to use his taser. That's why it's on his utility belt. It's one in the step of force that should be used until you get to deadly force. And Captain McCursey testified, I think very clearly, that he followed the continuum of force. He started with verbal commands, then he tried to arrest him, and then he used more physical efforts, hand-to-hand combat. Then he used his taser. He continued this whole time with verbal commands, and it was only when 3 minutes had gone by of hand-to-hand combat that he would not listen to the officer, that the suspect had the taser, which is a deadly weapon. Did he say one more time, drop the taser, and fired the shot? And to the people's point about he called it in, if you listen to the video, Officer Schurr can hear no sirens. He is waiting, fighting for his life, and there are no sirens. Sirens are important, and the reason they turn them on is to let everybody know other police are coming, and you cannot hear them. It's not for another minute that they showed up. And so it's not like if he had just hung in there for another 30 seconds. He is completely exhausted. If you watch the video, the moment after the shot is fired, he immediately turns to the passenger, who is encroaching on the situation, had been encouraging Mr. Loyola to get away, and yells with his last breath, "Get back." Because not only is he worried about Mr. Loyola, there's a passenger who's unidentified, who's approaching on the situation, who he has no idea who he is. He has no idea what's in that car. All he knows is it's 8 a.m., a Monday morning, and this person is fighting tooth and nail to get away from them.
Mr. Bergoli, you have about a minute left.
And I'll wrap up with that, Your Honor, unless there are any other questions. We ask that the court reverse the circuit court. Thank you.
That case is submitted. As I indicated, we will take a 15-minute recess.